Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about the Pathways Program, which is the program for resolving cases that was enacted by the Connecticut judicial system in 2021. It was shortly after kind of the COVID shutdowns. If you want to read about the program in more detail, it's governed by Connecticut Practice Book Section 25-50A. So if you do a Google search for that practice book section, you should find, in detail the whole program written out. But basically, how it works is after the divorce is filed or when it's filed, it is assigned a return date, which is, shortly after you file the divorce. And that is a set date after which the court will schedule what's called a resolution plan date about 30 to 60 days after the return date. So it has to be in that 30 to 60 day window following the return date. Now, on that resolution plan date, you first meet with family relations. So that's essentially a neutral family relations worker who works at the courthouse. They're very familiar with divorce and custody cases and the whole process. And they act as sort of a neutral mediator. So you will first meet with that person, either you or your attorneys or all four of you, and they will identify three things. First, they will identify any matters regarding your divorce or custody case where everybody agrees. So if you have an agreement on certain issues, they will identify those issues that are agreed upon. Then they will identify how likely the parties are to reach an agreement on any disputed issues after identifying the issues that are not agreed upon. And then third, they will identify the resources that are needed to resolve the case and the steps that need to be taken. And after determining those three things, family relations will put your case on one of three tracks. Track A is for cases that require the lowest level of court time and resources, and those are essentially cases that are fully resolved. If your case is fully resolved, you have a full agreement, it will go to Track A. Track B is for cases that are expected to require a moderate level of court time and resources, so they're not fully contested. Maybe you have an agreement on some issues and no agreement on others. And Track C is for cases with disputes about major issues that are expected to require the highest level of court time and resources. So you're one of three tracks, A, B, or C. And then on that resolution plan date, after you meet with family relations, the court will make a scheduling order that will include future court dates, and I'll get into the specific types of court dates that they will schedule. And they also may issue temporary orders on the resolution plan date for any pending motion. So leading up to the resolution plan date, somebody may file a motion for temporary custody to get a parenting plan put in place while the divorce is pending, or a motion for alimony pendente lite, asking for financial support while the divorce is pending, or child support pendente lite, which is again asking for financial support. Somebody may have filed a motion for referral to family relations for them to have more extensive services, or asking that a guardian ad litem be appointed, which is a central and neutral party who represents the best interest of the child. So those things can be heard on that resolution plan date, where temporary alimony may be put into place, a temporary parenting plan may be put into place, a guardian ad litem may be put into place, etc. Or it may be recommended for additional services with family relations. So some things that they may recommend are like a mediation, where saying, okay, let's schedule a future date for the parties to come in and meet with the family relations person for a couple of hours, sit down, go through the issues that are in dispute and see if we can resolve them. So a mediation might be scheduled for cases where, the family relations worker feels optimistic about the likelihood of reaching an agreement. Now, they may say, all right, there's no chance there's going to be an agreement unless we look into this in more detail. So they could also recommend what's called a comprehensive custody evaluation. And that is essentially done when there's really no hope of the parties reaching an agreement, but instead they're going to go in and look at this family in more detail, meet with both of the parties, meet with the child, meet with any collateral people, child psychologists, counselors, people at the school, meet with family members who know about the family dynamics, and really make a recommendation following that process. So a mediation is trying to get the parties to agree, and if they're not going to, there might be this custody evaluation where it is ultimately the family relations worker will be going through the process and making a recommendation that will hopefully help the parties reach an agreement. And if they can't, then that recommendation will go to the judge, and the judge will make a decision largely based on that recommendation following the custody evaluation. You also have to make sure that you file financial affidavits before the resolution plan date, assuming there are financial issues in dispute, which usually there are. If there's a divorce, there's always financial issues in dispute. And if there's custody, there likely is also, because there's going to be child support that you need to determine. So you're going to want to make sure you file a financial affidavit before your resolution plan date. And again, on that date, the court may hear some of these issues on that date: temporary custody, alimony, child support, etc. But they will also enter future scheduling orders. So they may say, okay, I don't have time to hear these issues today. Let's schedule it for a future date. They might schedule it for what's called a case date. And that is a specific day on which, the judge sits with your case and hears what you have to say, hears what your spouse has to say, and issues orders on these disputed matters. They may schedule you for what's called the motion docket, where you won't necessarily have your own set date and time, but if you're on the motion docket, it's a certain day when there's a whole bunch of other cases on the motion docket, and you go in and the judge will hear whatever issue you have. A case date is usually scheduled, for more complicated issues, or if it's issue that will require less of the court time, you will be put on a motion docket and be heard at that time. At the resolution plan date, the judge will also probably enter a discovery schedule. So in a divorce, you have to exchange certain documents. Usually it's financial documents, bank account statements, retirement account statements, etc. So they will probably enter a schedule by which you have to exchange those documents, or, maybe say you have to get depositions done by a certain date. And I've done other videos on what depositions are, so you can look those up if you're curious. So they will set that discovery schedule. They will assign a case date or set you to the motion docket. They may also schedule a pretrial, which is different than a motion docket. A motion docket, again, a judge is hearing your disputed issues and making a decision, whereas a pretrial is more of a settlement meeting. So that is where you and your spouse and your attorneys, if you have them, will sit down and meet with a neutral party, whether it's a judge or a family relations worker, or sometimes in some courthouses they have special masters pretrials where you're meeting with experienced family law attorneys who will give recommendations. But at that pretrial, you're sitting down with a neutral party and both sides make their pitch about what they think should happen in the divorce or custody case. And the neutral party, again, whether it's a judge or family relations worker, etc., they are making a recommendation about what they think should happen in their experience. And that is to help you try to reach an agreement. So the court might schedule you for a pretrial date, and ultimately on the resolution plan date, they may also set your trial date, which is the ultimate final date of your case, where if all of these issues cannot be resolved on the motion docket or at a case date or during a pretrial, ultimately you will have to have a trial, and that is where you're presenting evidence and a judge is making a final decision on your case. Now, the trial date isn't necessarily set on the resolution plan date. They may just set your case date or put you on the motion docket and then set your trial date on a later date. It really depends on the jurisdiction. Every courthouse sort of handles this process a little bit differently. So depending on where you are, you may get more done on your resolution plan date. You may, for example, have a hearing on that date to resolve disputed issues, or you may get scheduled for a later date. So those are the basics of the Pathways program. Again, you are set on that path A, B, or C, depending on the complexity of the case and the likelihood of reaching an agreement and the amount of court resources that will be needed to resolve your case. As usual, if you have any additional questions about this process, we would invite you to contact our office. And if you are looking for representation in a divorce or family law case, you should contact our office as well.